appeal in the matter of the Information Commissioner and the DSG Retail Ltd.
Yes.
Good morning, my lords, my lady. I appear with Mr. Lockley for the Information Commissioner and my learned friend Mr. Payne, KC, with Mr. Payne's. Here's the DSG, and I hope you have two bundles, a core and supplementary one, and an agreed bundle of sidelined authorities.
I think so. Yes, thank you.
So this appeal raises a point on the interpretation of the data security duty in the Data Protection Act 1998, which we say ultimately has a straightforward answer. And that's the answer given by the First-tier Tribunal, paragraphs 92 to 96 of its judgment. And the Upper Tribunal's approach and DSG's arguments, we say, don't detract from the First-tier Tribunal's pithy and correct reasoning. The data security duty requires the data controller to take appropriate technical and organisational measures to protect the personal data that it holds from, among other things, unauthorised or unlawful processing. Personal data is data from which a natural individual can be directly or indirectly identified, and data which relates to an individual who can be identified only when the data is combined with other information, which the data controller holds, is still personal data. So that includes, for example, pseudonymized data, whereas here the data controller holds the information necessary to unlock it. Both parties and the Upper Tribunal are agreed that DPP7 is a duty which applies to all the personal data which the data controller holds. And both parties and the Upper Tribunal are also agreed that it is an anticipatory duty which applies both at the time that the processing system is designed and at all times when the data controller holds personal data. And we say it must inevitably follow that the duty in DPP7 to protect personal data from unauthorised or unlawful processing applies to any personal data in the data controller's hands, even if that same data would not be personal data in the hands of a third party carrying out unauthorised or unlawful processing because they didn't have the information to unlock it. And we say that follows as a matter of the ordinary language of the 1998 Act, and the respondent's approach requires personal data to mean two different things in the very same provision of the Act, which we say can't be right. And we also say that the Upper Tribunal's approach would lead to anomalous or undesirable consequences. It would make it unclear what data controllers needed to do to protect the security of personal data, and it would lead to regulatory risks and gaps. And we say that the correctness of the First-tier Tribunal's position is confirmed and supported by recent CJEU case law, the recent case of the Single Resolution Board and European Data Protection Supervisor, addressed in our supplementary skeleton. And by contrast, the respondent's approach, we say, is based upon the misapplication of domestic case law from a very different context, which concerns the controlled release of information to the public under the Freedom of Information Act. Now, the respondent's argument, we say, is based upon a central logical fallacy, which runs like a leitmotif through the respondent's skeleton. And it may be helpful to identify it now. It is in paragraph 35 of the respondent's skeleton argument, which sets out a series of propositions. That's core bundle page 219. And dealing with those propositions in paragraph 35, we agree with one. The EMV obviously being a reference to personal account numbers plus numbers on the front of cards. 2 is plainly wrong insofar as we say that DSG has held the data in non-compliance with DPP7 and simply holding the data is an act of processing. But we don't suggest that other than holding the data in non-compliance with DPP7, DSG have processed the data unlawfully. Point 3 is correct, although it's important to note that it is a matter of assumed facts for the purposes of this appeal rather than established facts. Point 4, we say, is the central fallacy. It doesn't follow from point 3. The therefore is wrong. For the purposes of DPP7, the relevant question is whether personal data held by the data controller is at risk of being processed in a way that is unauthorised or unlawful. To answer that question, you look at all personal data held by the data controller, which includes pseudonymised data. The fact that the processing of that data itself might be carried out by a third party does not mean that you switch perspective to consider whether it would be personal data for the putative third party who might process it. All you need to ask is it personal data for the data controller? And for these purposes, it's critical to appreciate that the definition of processing in the Act is a very broad one, which includes absolutely anything that might be done with data. And there's no logical reason why an act of processing of personal data must be carried out only by a person who can identify the individuals to whom the data relate. At the simplest level, we say, a criminal hacker who entered a data controller's system and destroyed or encrypted personal data without having the faintest idea or means of knowing who the data belonged to would be engaging in an act of processing of the data controller's personal data, to which DPP7 applies. And the data controller holding the data would have a duty to guard against it. Indeed, we say it would be bizarre if they didn't. And that fallacy in subparagraph 4 of paragraph 35 is repeated in different forms throughout the respondent's skeleton argument. And in substance, it's the same fallacy that one finds in the critical bits of the Upper Tribunal's judgment in paragraphs 112 and 123. So that's setting out our stall.
Yes.
And what I propose to do is, if it's acceptable to my lords and my ladies, to structure the submissions in 4 parts. First of all, to take you through the relevant concepts in the language of the 1998 Act and address why, as a matter of ordinary language, we say the respondents' and Upper Tribunal's approach doesn't make sense. Then, secondly, explain why the Upper Tribunal's approach gives rise to a number of regulatory gaps and difficulties and address what the respondent says about that. Thirdly, to deal with the single resolution board case from the CJEU and why we say it strongly supports the Information Commissioner's case. And fourthly, to deal with the domestic authorities on FOIA, which conclude that in the context of the controlled disclosure of information, you need to consider whether the information is personal data from the perspective of the public to whom it's disclosed. And I will explain why we say that approach doesn't read across to the data security duty in DPP7. So I'll start with the first of those 4 points, which is the concepts and language of the 1998 Act. And starting with the critical definitions, you have those in tab 2 of the authorities, starting at page 12, section 1, basic interpretative provisions. So section 1 sets out the definition of data, first of all, including any computer processed information. And below that, towards the bottom of the page, you have the definition of personal data.
Yes.
And there are two parts to that. Subparagraph A is data relating to a living individual who can be identified from those data, so no additional information required. So would include, as in this case, payment card information linked to a name. Subparagraph B is data relating to a living individual who can be identified from those data and other information which is in the possession of, or is likely to come into the possession of, the data controller. And it's subparagraph B that this appeal is concerned with. Now I need to unpack that definition a bit and explain how it applies here. First of all, obviously, where a person has pseudonymized data and keeps the data in one place and the information which enables identification in another, the pseudonymized data remains personal data in that person's hands. It only stops being personal data if it's been put into a form in which individuals are irreversibly anonymized. And there's no dispute here on that approach that all the EMV card data, in this case, personal account number plus expiry date on cards, was personal data in DSG's hands because DSG had the other information necessary to link those card details to specific individuals. Subparagraph B, personal data, would also include data where a data controller didn't themselves possess the means of identification, but where there was a means likely reasonably to be used by them to effect identification. That's not this case, but it's another type of subparagraph B information. And the language that I've just adopted means reasonably likely to be used. It's not in the Act, but it's in recital 26 to the directive which the Act implements, and it's common ground between us that the definition in the Act is intended to implement the directive and must be read in light of it. It may just be helpful to turn up recital 26, which you've got in tab 1, page 4. And you'll see there, recital 26 says, whereas the principles of protection must apply to any information concerning an identified or identifiable person, whereas to determine whether a person is identifiable, account should be taken of all the means likely reasonably to be used, either by the controller or by any other person to identify the said person, whereas the principles of protection shall not apply to data rendered anonymous in such a way that the data subject is no longer identifiable. So that's the relevant bit of the recital. And the wording of that recital and the reference to the means likely reasonably to be used either by the controller or by any other person gives rise to a further question which can be posed this way. What if person A has the relevant data containing personal information, but they've got no means of identifying the individuals in it and can't get hold of such means? Another person B does have those means. Is the data nevertheless personal data for person A? And the answer is no. And that is because, according to the case law, where a person doesn't reasonably have access to any means enabling them to identify the person to whom the data relates, then the data is not to be regarded as personal data for them, even if it might be personal data for someone else. So it may be necessary to consider whether data is personal data from different perspectives. And there's a clear illustration of that point in the Scania case from the CJU, which you've got at Authorities tab 15. So that was a case which concerned whether VINs, for vehicle identification numbers, were personal data. And the context, as one sees from paragraph 16 on page 452, is that Scania, a vehicle manufacturer, granted access to information about its vehicles on a website, which enabled vehicles to be searched by VINs. You input the last 7 numbers of the VIN and it comes up with the vehicle. And one of the questions that arose was whether VINs were personal data because they could be linked to the owners of vehicles via a vehicle's registration document. Because if so, Scania would have needed a proper basis under the GDPR for processing that data on its website. And that question is answered starting at paragraph 44 on page 457. And as one sees, just shortly, as one sees from paragraph 44, Scania is a case about the meaning of personal data under Article 4.1 of the EU GDPR, but the wording of recital 26, which I've taken you to, and the wording of the GDPR, which replaced the directive, are materially the same. And in fact, in paragraph 45, the Scania judgment refers to Breyer, which is a CJU case about the directive, not the GDPR. If one then goes to paragraph 46, that says datum such as a VIN is not itself personal, but may become personal as regards someone who reasonably has means enabling the datum to be associated with a specific person. Paragraph 47, the registration document for a vehicle has both the VIN number on it and the personal details of any natural person to whom the vehicle belongs. And then paragraph 48 is the important point. The VIN constitutes personal data insofar as the person who has access to it may have means enabling him to use it to identify the owner of the vehicle to which it relates. So if you, as the data controller, do have the means of accessing the registration document or otherwise know who is the natural person who owns the car, the VIN is personal data. But if you don't have the means of accessing the registration document, and you don't have the means of knowing who the owner of the vehicle is, then it isn't personal data. Now, for the purposes of this hearing,
But sorry, what was the effect of that? What was the effect of that? What was the outcome in terms of what Scania had done with the VIN data?
That it could be personal data, and they needed a basis for processing it, but they had such a basis. Was in essence where the judgment cashes out at. But for these purposes, that bit is unimportant because all one needs to look at from Scania is how does the definition of personal data work.
But it was still decided that it would have been a breach of the data protection regulations for Scania to put it on the website because it was personal data.
It was personal data, but not a breach because there's a basis for processing.
I see. Okay.
So yes. So having
in whose hands was it personal data?
Well, it would be personal data in the hands of the people who had of anyone who had the means of linking it back to.
Not in Scania's hands.
Well, Scania actually did have the means.
They did.
Yes.
Okay, but you could have hypothetically a situation where Scania didn't have the means because the registration certificates were not accessible to them, but third parties did, which would be the reverse of the hypothetical situation or the actual situation we're contemplating in this case.
Yes.
In that situation, if appropriate technical measures weren't taken to avoid the non-personal data passing from the hands of the data controller into the third party's hands, where it would become personal data, or there be a breach or no breach?
Well, it would depend whether the data controller themselves could reasonably likely get hold of the means enabling it to be personal data in their hands, my lord.
It was entirely
If they
anonymous
couldn't, and
in
it's
their
entirely vanilla data in their hands and could only ever be vanilla data in their hands, then we say that that DPP7 wouldn't apply because it just wouldn't be personal data in their hands.
Yeah, thank you.
So for the purposes of this hearing only, the assumption is that the hackers who stole the EMV data from DSG didn't have the means of finding out who were the owners of the debit or credit cards in question. And therefore, the EMV data wasn't personal data for them. Now, that's actually not an issue which has been determined by the First-tier Tribunal. It's simply the premise upon which this appeal is being run. As a final point on the definition of personal data in section 1, it may be worth noting that the First-tier Tribunal and Upper Tribunal in this case use their own tripartite analysis of personal data, which one finds at page 60 of the core bundle, paragraph 67 of judgment. Lim 1, Lim 2 and Lim 3. Using those limbs, it's accepted that the EMV data was Lim 2 personal data in DSG's hands, and it's also assumed for the purposes of this appeal that it's not Lim 2 or Lim 3 personal data in the hands of the hackers. But obviously the intention behind these limbs is to capture the idea that you're looking from DSG's perspective when considering Lim 2 and from the hacker's perspective when considering Lim 3. But those limbs, in my submission, don't map very clearly onto the statutory definition in section 1 of the DPA, and it's better and clearer just to look at the statute. So that's what we need to say about the definition of personal data. And coming back to the other core concepts in section 1 of the Act at page 12 of the authorities, I can be shorter about the others.
Sorry, where are we again?
So we're now back in tab 2, page 12, my lord.
Thank you. Yes.
So just above the definition of personal data, you have the definitions of data controller and data processor. Data controller, in relation to personal data, is a person who alone or jointly with or in common with other persons determines the purposes for which and the manner in which any personal data are to be processed. And below that, data processor in relation to personal data means any person other than an employee of the data controller who processes the data on behalf of the data controller. And those are the only relevant persons on whom the Act imposes duties. And then at the bottom of the same page, you have the definition of processing in respect of data. And that's very widely defined. It includes obtaining the information, holding the information, or carrying out any operation or set of operations on it. And as one can see, that includes disclosing it, using it, blocking it, erasing it, or destroying it. In essence, it is anything that can be done with data. And my Lord Justice Warby said in the NTL case, and it's cited in the respondent's skeleton argument at paragraph 22, that processing is a very widely defined concept encompassing almost any dealings with personal data, including holding the data and disclosing it or the information in it, and we gratefully adopt that. And within that definition of processing in the 1998 Act, there is no requirement that processing be done by any particular person. It's simply a description of any act that can be performed by anyone on data. It isn't tied to whether the data is personal for the person doing the processing. And pausing there, all sorts of examples might obviously be given of the processing of personal data not by the data controller. If I hold, say, a client's personal data on a memory stick, and I drop the memory stick in the road and a car runs over it and destroys it and crushes it so you can't get anything out of it, that personal data has been destroyed. And the accidental destruction will be an act of processing within the meaning of the act, which I, as a barrister and data controller in my own right, would have a duty to guard against. But the individual doing the destroying won't be me as the data controller, it'll be the car driver. And equally, one can posit an example closer to the present case of a data controller who holds pseudonymized personal data on a computer system and the key to decode it in another secure part of the system. A hacker who hacks into the system may deliberately delete the pseudonymized data without knowing or having any basis for knowing who it relates to. And that deliberate destruction, we say, is clearly an act of processing of the personal data for which the controller is responsible, even if the hacker can't identify who the data relates to and isn't therefore themselves a data controller in respect of the data. So those are the basic concepts in section 1. And then moving on through the Act.
Could I just ask, in the scenario we have here, where a third party or more than one have gained access to data in the various ways described, do they become a data controller?
Only if they have the means of identifying, either get the identifying information at the same time or have some means of getting hold of it. Otherwise, the personal data is not personal data in their hands, and they can't be a data controller.
Yeah.
So they won't be liable under the Act. They will have done a series of other wrongs, whether it's Computer Misuse Act or...
That's not subject to the duties.
Yes,
Unless the information is personal data in their hands.
yes, yes. Then moving through the Act, at tab 2, page 15, you have the overarching duty in section 4 to comply with the data protection principles, which sets out the duties applicable to data controllers. And one sees at 4 sub 1 that references in this Act to the data protection principles are to the principles set out in part 1 of schedule 1, which I'll also be going to. And then critically 4 sub 4, which we say sets the overall context for all of the data protection principles. Subject to section 27.1, which is exemptions, it shall be the duty of a data controller to comply with the data protection principles in relation to all personal data with respect to which he is the data controller. So it's a comprehensive duty that applies to everything that is personal data in the controller's hands. And that duty obviously bites in respect of pseudonymized personal data under limb B of the definition of personal data, just as it bites in respect of personal data under limb A. So that's section 4. And one then comes to the DPP themselves in schedule 1, which start at page 20. And there are 8 of them, and it's worth looking at the others because it sets the context in my submission for DPP 7, paragraph 7. So paragraph 1 the obligation of fair and lawful processing. Personal data should be processed fairly and lawfully, and in particular shan't be processed unless at least one of the conditions in Schedule 2 is met, or in the case of sensitive personal data, at least one of the conditions in Schedule 3 is also met. Paragraph 2 is what's called purpose limitation. Personal data shall be obtained only for one or more specified and lawful purposes and shall not be further processed in any manner incompatible with the purpose or those purposes. Paragraph 3, data minimisation. Personal data shall be adequate, relevant, and not excessive in relation to the purpose or purposes for which they're processed. Paragraph 4 is accuracy. Personal data should be accurate and, where necessary, kept up to date. Paragraph 5, retention. Personal data processed for any purpose or purposes shall not be kept for any longer than is necessary for that purpose or those purposes. Paragraph 6, personal data should be processed in accordance with the rights of data subject under the Act. I'll come back to 7 in a moment. And then paragraph 8, at page 27, personal data shall not be transferred to a country or territory outside the EEA unless that country or territory ensures an adequate level of protection for the rights and freedoms of data subjects in relation to the processing. Now, each and every one of those duties that I've just taken you to obviously requires one to consider what is personal data in the hands of the data controller subject to the duty. They impose duties on the data controller in respect of all the personal information the controller holds, and in each respect, one's clearly looking at the meaning of personal data from the perspective of the data controller themselves. So that's the context, we say, in which one turns to the critical paragraph, paragraph 7, page 26, DPP 7. Appropriate technical and organisational measures should be taken against unauthorised or unlawful processing of personal data and against accidental loss or destruction of or damage to personal data. And we say the obvious reading of that duty, all the more so against the terms of section 4, sub 4 of the Act, and all the other data protection principles that I've just taken you to, is that the references there to personal data are references to everything that is personal data in the hands of the data controller subject to the data security duty. And the final bit of the Act that's relevant to look at is Part 2 of Schedule 1 to the Act, which fleshes out the data protection principles. And there are a couple of relevant paragraphs there. First of all, paragraph 9, which you've got at page 36. Now, so that says that having regard to the state of technological development and the costs of implementing any measures, the measures must ensure a level of security appropriate to A, the harm that might result from such unauthorised or unlawful processing or accidental loss, destruction or damage, as I mentioned in the 7th principle, and B, the nature of the data to be protected. And we say that's significant because it emphasises that DPP7 is an anticipatory duty. It requires the data controller to predict the harm that might result and take steps to prevent it. And the other relevant paragraph is paragraph 11 on page 38. And that's the obligation on a data controller to choose a data processor, so someone who may be processing data on their behalf, providing sufficient guarantees. And the wording of this, we say, is significant. Where processing of personal data is carried out by a data processor on behalf of a data controller, the data controller must, in order to comply with the 7th principle, A, choose a data processor providing sufficient guarantees in respect of add-ons, and B, take reasonable steps to ensure compliance with those measures. And it's significant, we say, that this paragraph refers to processing of personal data by someone other than a data controller, in this case the data processor, but does so in a context, we say, which must refer to what is personal data in the controller's hands. So that's the relevant bits of the Act I've taken you to, which brings me to my submissions on the language of DPP 7 at page 26. And we say it would be bizarre as a matter of language if, for the purposes of preventing unauthorised or unlawful processing by a third party, the perspective from which personal data was to be viewed in DPP 7 suddenly swung round, so that it had to be considered not from the data controller's point of view, but from the third party's point of view. And that is especially so because every other reference in personal data, in section 4 of the Act, every other reference to personal data in all of the data protection principles, we say, is clearly a reference to personal data in the hands of and from the perspective of the data controller. So that natural language in my submission speaks for itself, but it also needs to be seen in light of basic principles of statutory interpretation. And we say there are two relevant principles here. First, where you've got a statutorily defined term, as is the case with personal data in section 1 of the Act, then the term should bear that statutory meaning throughout the Act, even where there's a saving clause for where the context otherwise requires. And it will virtually never be the case that a savings clause should bear the load of justifying giving a statutorily defined term different meanings in different provisions of the same Act. And we've given at paragraph 38A of the skeleton a citation from a speech of Lord Justice Sedley, where he says that the saving clause device is to spare the drafter embarrassment, and the only examples given in Benyon are from the 19th century. I don't need to take you to that, but here, the relevant statutory definition, if one goes back to page 12 in tab 2 of the authorities, is data which relate to a living individual who can be identified from those data and other information which is in the possession of or likely to come into the possession of the data controller. So the statutory definition itself expressly ties the concept of personal data to the data controller subject to the relevant duties under the Act. And in that context, we say, it would be extremely odd if in the first part of DPP 7 at page 26, concerning unauthorised or unlawful processing of personal data, one suddenly had to view personal data from a different perspective, from the perspective of a third party who got hold of it, rather than from the perspective of the data controller subject to the data security duty. And that statutory definition also explains why the respondent's suggestion in its skeleton argument that we're asking for additional words to be read into the Act is, we say, obviously wrong. There's a suggestion there, and it's page 224, if one would like to turn it up.
224.
224 of the core bundle.
Right.
So the suggestion there is that the relevant part of DPP 7 would need to be rewritten so that it referred to processing of personal data by a third party that would be processing of personal data if the same data were processed by the controller. And we say the straightforward and complete answer to that is that personal data is defined in section 1 of the Act as personal data from the data controller's perspective. So you clearly don't need to read in any extra words to get that result. On the contrary, we say, if the respondent was right, DPP 7 would need to have extra words in it that would say something like, appropriate measures shall be taken against unauthorised or unlawful processing of personal data to the extent that it's personal data when viewed from the perspective of the person carrying out the processing. So that's the first point on the principles of linguistic interpretation. And secondly, there's a principle stated by the Supreme Court in Webb and Webb, quoted at paragraph 38b of our skeleton, Core Bundle 200, that words in the same act, and surely all the more so when found in the same section, are presumed to have the same meaning. And that's a particularly potent principle of interpretation, where what you're being asked to do is to give a different content to the term personal data when it's used twice in a single sentence of DPP7 concerning a single data security duty. Now, as one can see from DPP7, just going back to page 26 of the authorities, the way in which the duty is framed sets up two broad categories of harm to be guarded against, reflected in two limbs of the provision, if you like. You've got two sense units linked by a conjunction and, with the words personal data at the end of each. And the first limb is unauthorised or unlawful processing of personal data, that is, deliberate harm. And the second, we say, is accidental harm, that is, accidental loss or destruction of or damage to personal data. As a matter of ordinary language, one would assume that they are intended to deal with two different species of harm, the first deliberate and the second accidental, but each in respect of the same subject matter, personal data. And we say it would be very strange, just as a matter of common sense, quite apart from the point in Webb and Webb, that if in each sense unit the term personal data had a different meaning. Now, looking at the way the Upper Tribunal analysed these sense units in its judgment, that is at Core Bundle page 77, paragraph 117.
So which paragraph again?
117, my lord.
Thank you.
So one sees it starting in the third line, that we accept the DPP7 duty lies on the data controller in respect of all the personal data that it holds, and we say that is right. As to the latter, DPP7 imposes an obligation on data controller to take appropriate steps to guard against two different kinds of risk. And we say that's right too, deliberate and accidental. They then say the first risk it covers is the one we've just discussed, namely the risk of third parties undertaking unauthorised or unlawful processing of personal data. Now, that is not quite right, because unauthorised or unlawful processing can, actually, as both parties agree, be carried out by the controller itself through its own employees, at least where employees are acting unlawfully but within the scope of their authority. And then it says, however, the data controller is also required to take appropriate steps to guard against the distinct risk of accidental loss or destruction of or damage to personal data. In this scenario, the risk to be guarded against is the inadvertent actions of the data controller who accidentally loses, damages, or destroys personal data which is in its possession. Now, again, we say it's right to bifurcate this into deliberate versus accidental processing, but it is wrong to assume that accidental processing necessarily needs to be carried out by the data controller itself. And I gave you the example of the car running over my memory stick. So we say the Upper Tribunal got it right in terms of recognising these distinct limbs in paragraph 117, but wrong in terms of stating that the first limb had to be processing by a third party and the second limb had to be processing by the data controller itself. There's one more point to add on the structure of the Act. Of course, if a third party steals your personal data and knows who the data subjects are and then uses it to do various nefarious things, they will themselves be a data controller in respect of that data, and they will be liable as a data controller for the things they do or don't do. And that's the Morrison's case at tab 8 of your authorities, which my learned friends address at paragraphs 31 to 34 of their skeleton. That was a case where, I'm not sure we need to turn it up, but I'll just say that was a case where a rogue employee had stolen employee data from Morrison's and posted it on a file sharing website. And the question was whether Morrison's was either directly or vicariously liable for the things that the rogue employee had done with data. And the answer was no, because the acts were the employee's own acts, which he'd done for criminal purposes without authority. So he and not Morrison's was the relevant data controller. But that doesn't mean, and in fact Morrison's makes this point, and I will ask you to turn it up, that doesn't mean that the original data controller cannot itself be liable as well under DPP 7, which for any security failures which led to the nefarious actor being able to do the things he did. Because as Morrison's itself points out, DPP 7 raises different issues. And the point's crisply made in the Morrison's judgment at tab 8 of your authorities, page 208.
Yes.
So one sees paragraph 65, the short answer to the claim that Morrison's is liable under the DPP for having broken the data protection principles other than DPP 7 is that it did not, as data controller itself, offend against those principles. The Act said to break them with those of a third party and not its own. Then paragraph 67, DPP 7, however, raises different issues to which I will turn. And one sees what those issues are from page 209. DPP 7 stands apart from DPP 1, 2, 3 and 5 in that Morrison's was undoubtedly the data controller in respect of the relevant information at the time when the duty fell to be discharged. If appropriate technical and organisational measures were not taken by Morrison's against unauthorised or unlawful processing of personal data, then provided them the claimants could show that that breach of that duty had caused the disclosure which is central to their complaints, liability would be made out. So that is what we wanted to say about the structure and language of the Act. And perhaps I can just recapitulate what our key points are. The key points we say are, first, DPP 7, like all 8 of the data protection principles in Schedule 1, is a duty placed on a controller in relation to all personal data with respect to which he is the data controller, section 4, sub 4. Second, DPP 7 has 2 limbs reflecting 2 categories of harm, deliberate and accidental, but it doesn't draw hard and fast rules about who would be doing the processing that must be guarded against in each case. And in that context, it's obvious and natural, we say, to read the words personal data as they occur in the phrase unauthorised and unlawful processing of personal data in the same way as every other time they appear in Schedule 1. That is, as including any data that is personal data from the perspective of the data controller to which the duty applies in the first place, regardless of who carries out the processing. And that linguistic approach, we say, is the complete reason why this appeal should succeed. So that's my first topic. So what I'm now going to move on to is the second of my four broad heads, which is the regulatory gaps and difficulties which the Upper Tribunal's approach would create. And we say the construction against absurdity is a strong pointer to the meaning of the Act in this context. And we rely on the Packard case, which is tab 14 of your authorities, page 372 in the speech of Lord Sales. It's paragraph 43 at the bottom of the page. And we draw out 2 points from that paragraph. First of all, at the bottom of the page, absurdity has a wide meaning. It includes results that are impracticable, inconvenient, anomalous, or illogical, futile or pointless, artificial, or productive of disproportionate counter-mischief. And we say that the Upper Tribunal's construction is all of those things, except perhaps futile or pointless, but certainly all the others. Secondly, the strength of the presumption is flexible and depends upon the extent to which a particular construction produces an unreasonable result, and that's over the page. And we say that the Upper Tribunal's construction produces, both from a regulatory point of view, so looking at it from the Information Commissioner's perspective, and from the perspective of protection of personal data generally, a highly unreasonable result. So the presumption, we say, is a strong one in this case, for reasons I'll set out. And I should perhaps start by emphasising that the Commissioner considers this issue to be of continuing importance to the current regulation of data controllers, because he takes the view that controllers, and indeed tribunals or courts, are likely to read whatever is said about the correct approach to the 1998 Act across to the current data protection regime in the UK GDPR. And that's because the definitions of personal data and the wording of the data controller's data security duty under Article 5 of the UK GDPR are very similar to those in the 1998 Act. Now, dealing with the mischiefs to which we say the Upper Tribunal's approach would give rise, first of all, personal data is obviously a core concept of data protection law, and from the Commissioner's perspective, it's critical that data controllers know how to apply it. And having to apply a shifting perspective to whether material is personal data, which depends on the nature of the harm guarded against, we say would not be conducive to clarity and good understanding. But more than that, the Commissioner considers that it would be likely to lead data controllers to apply lax security measures. If controllers believe that they have entirely discharged their duty to guard against unauthorised or unlawful processing, because no third party can identify the data subjects in pseudonymised data, then they will have failed to guard personal data against the range of possible harms, we say. Most obviously, they won't have protected it against the possibility of it being put beyond use by a third party who can't identify the data subjects within it. And That's in a context where, as the court will be aware, there's been a massive increase in the risk from and numbers of cyber attacks over recent years. And hackers will often use ransomware. The hacker will exfiltrate data and ask for payment to return it, or they'll encrypt it on the controller's systems and ask for payment to unlock it. And neither of those forms of cyber attack requires the hacker actually to be able to identify data subjects at all. Or the hacker may simply destroy personal data or damage it. Sometimes data of great sensitivity, medical data, for instance, in a hack of a hospital's systems. And again, that doesn't require them to be able to identify any of the data subjects within it. And we say it would be an unacceptable and perverse regulatory outcome if DPP7 failed properly to protect against such a danger. In addition, we say, data controllers may have very unrealistic notions of how readily criminal hackers may be able to re-identify data subjects in pseudonymized data using information available on the dark web or other forms of analysis. Hackers, for instance, may be highly sophisticated state entities. The danger in the Upper Tribunal's reading of the DPP7 duty is that it encourages data controllers to think that they've done enough if the key to pseudonymized data is held securely, rather than making sure that the pseudonymized data itself is held securely. And that may make it easier for a bad actor to get hold of pseudonymized data, use other means of identifying data subjects, and then cause them various forms of harm.
Well, it's also entirely speculative because it's based on what may or may not be available to or reasonably available to the hacker, and that is, you have no idea.
Precisely the same. Yes.
So it's a retrospective analysis based on, I mean, say you're guarding. I mean, if you're always looking at it from the point of view of the person who is the third party who's processing it, that is a very speculative, unsure foundation.
Yes.
To what you're saying.
Yes, that is exactly what we're saying. And this shifting notion of the meaning of personal data means that data controllers may also decide not to notify the commissioner about cyber attacks where the personal data that's been compromised is pseudonymized, because they may take the view that there cannot have been a breach of the data security duty because a third party can't find out who the data subjects are. And we say that too would be likely to undermine the protective regime. Now, so those are the mischiefs that we say would be caused by the Upper Tribunal's interpretation. And my learned friends have made various points in response in their skeleton that I should deal with. And this is what they term as the lacuna point. And what they say about it starts at paragraph 61 of their skeleton, core bundle, page 226. So, first of all, they say, and picking it up at paragraph 61 at the bottom of that page, 62, it's not self-evident that the DPA should protect against malicious destruction of data by a third party. And we say that cannot possibly be right. So I'm so sorry. So this is 61 and the beginning of 62, where they say Commissioner's argument depends on the implicit premise that the DPA.
Thank you.
And we say that can't possibly be right, because the risk of personal data being destroyed or damaged or put beyond use by a third party, whether or not they know who the data subjects are, is a patent and obvious risk that an effective data security duty must be intended to cover. And it's no answer to say, as the end of that paragraph does, well, the many kinds of loss arising from data processing that DPA doesn't cover, such as fraud on corporate finances, because that's a straw man. Fraud on corporate finances wouldn't involve the processing of personal data at all, which is what the Act is concerned with, and fraud is its own separate species of wrong, which isn't to do with data security. So that's the first point. Then they say at paragraph 63 and following, the word accidental in DPP7 only qualifies loss and not destruction or damage, and therefore obligation 2, as they term it, so that's the duty to protect against accidental loss, destruction or damage. Obligation 2 will cover, they say, deliberate destruction or damage by a third party. Now that submission is picking up on the reasoning given by the Upper Tribunal in its refusal of permission to appeal to this court at Core Bundle page 91. And they give various reasons why they say that that analysis is the case. And I should pick up on those reasons, and we have 6 points in answer to them. And it may just be helpful when I give you those 6 points just to have DPP7 up so that one can clearly see how the language cross-relates across. So page 26 of the authorities tab 2. So, just rooting to the language of the Act, what's being said by DSG is that the word accidental qualifies loss, but doesn't qualify destruction or damage. And we have 6 points in response. First of all, it's not what the language of the obligation says. As already explained, the language of DPP7 is structured so that it deals with 2 different categories of harm, deliberate and accidental. And just as a matter of ordinary syntax, without repeating my earlier submissions, accidental must be clearly intended to qualify all the words that follow it: loss, damage, and destruction. Secondly, that is what the Upper Tribunal itself correctly found, paragraph 117 of its decision. And insofar as the permission to appeal reasons say something different, they're inconsistent with the Upper Tribunal's own reasoning. Thirdly, there is an internal logical inconsistency in DSG's argument. It's important to note that destruction or damage to data are forms of data processing. And just like the first limb of DPP7, unauthorised or unlawful processing of personal data, the second limb of DPP7 also applies to destruction or damage of personal data, not simply data. And it must follow, we say, that if DSG's approach were applied consistently and logically, the second limb of DPP7 wouldn't cover destruction or damage of personal data by a third party who didn't know the identity of data subjects any more than the first limb would. DSG says DPP7 only applies to a third party's unlawful or unauthorised processing. But why is the same not if they know that it's personal data? But why is the same not equally true of damage or destruction? This is what sauce for the goose is sauce for the gander, is what I say about that. And DSG doesn't grapple with that point. Fourthly, DSG argues that on the Commissioner's approach, obligation 2 is entirely subsumed in obligation 1. And that's paragraph 65 sub 2 of their skeleton, page 228. And we don't understand that. Obligation 1 concerns deliberate harms, unauthorised or unlawful processing. Obligation 2 concerns accidental harms. They are different species of harm. It may be that there's some very subtle point being made here about all accidental harm being unlawful because the data controller won't have a proper basis for processing, but we don't understand that point. It's not common sense, because as I've already explained, an accidental act of destruction or damage doesn't need to be carried out by the data controller at all. We also note the final sentence of paragraph 65(2) of the skeleton, which says obligation 2 requires a controller to protect itself from damage or destruction, which is not itself processing of personal data. And presumably what's meant by that is not processing of personal data in the hands of the person doing the damage or destruction. But that seems to us to concede the very point on obligation 2 that DSG says is an impossible construction of obligation 1. Fifthly, it's paragraph 65(3) of the skeleton. DSG relies on the language of the directive. We say, on the contrary, the language of the directive strongly supports the Information Commissioner's position. And perhaps we turn it up, and it's tab 1 at page 10. Tab 1 of the authorities, page 10. So this is the data security duty as it's found in Article 17 of the directive. And the first thing to say is that the harms are obviously structured differently in the directive, because the directive doesn't do what DPP 7 does do, which is to clearly bifurcate, on the one hand, unlawful or unauthorised processing from accidental loss, destruction or damage. But what the directive does do is to state at the very beginning of the list of harms that the controller must take appropriate technical and organisational measures to guard against, is to say that they are all measures to protect personal data. And that way of structuring the obligation strongly indicates that the term personal data doesn't bear a different meaning depending upon which harm you're talking about, or whether the harm is the result of the data controller's own actions or the actions of a third party. Also, the directive does state explicitly that unlawful destruction is one of the harms that must be guarded against. So one way or another, DPP 7 must be construed to include that form of harm for that further reason. And we say no problem in doing that because it's a form of unauthorised or unlawful processing by either the data controller or a third party. So that is what is said about the directive. Then finally, at paragraph 65 sub 4 of DSG skeleton, page 229, what's said here is that malicious loss and damage could be understood as accidental from the perspective of the controller, so that you could get it within the second limb. And that, we say, is completely counterintuitive. It just doesn't make sense to suggest that when a third party maliciously hacks into your systems and destroys your data, that is accidental damage from your point of view. It's malicious damage by a third party that you, the data controller, may have taken inadequate steps to guard against. So none of those reasons why it said there isn't a lacuna in the Act if DSG's or the Upper Tribunal's approach is adopted. None of those reasons we say is tenable. And there are a couple of final observations to make before I move on from my second topic, as it were. The first is this, and DSG submissions are all aimed at showing there isn't a regulatory gap on its approach, because it says the words destruction or damage in the second limb of DPP7 include malicious destruction or damage of personal data by a third party who doesn't know the identity of the data subjects. That's their essential point. But even if one were to assume that destruction or damage included malicious destruction or damage, there would still be a serious regulatory gap. A third party who doesn't know the identity of data subjects can still harm them by processing their personal data without destroying it or damaging it. The obvious example is encryption. A hacker can, and frequently will, go into a computer system and put an encryption lock around data and then ransom it. And that doesn't necessarily involve destruction of or damage to personal data at all. But it's still a form of unauthorized and unlawful processing of personal data that DPP7 should obviously guard against. On the Commissioner's approach, DPP7 does cover that danger, and on DSG's approach, it doesn't. So we say there would still be an important regulatory gap, even if the approach taken by DSG of interpreting destruction and damage under the accidental limb as including malicious destruction or damage were adopted. And the second and last point in this question of the overall harms concerns paragraph 11 of part 2 to schedule 1 of the Act, which is page 38 of the authorities. So that's the obligation to choose a data processor providing sufficient guarantees in respect of atoms, which specifically refers to processing of personal data carried out by a data processor on behalf of the data controller. Now, the logic of DSG's argument, we say, must be that whenever the Act uses the language, the processing of personal data, it is concerned with processing by a person from whose perspective the data is personal. The person doing it must be able to identify the data subjects. But we say that can't possibly be the case in paragraph 11. Paragraph 11 must be referring to personal data from the controller's perspective, not from the processor's perspective, because otherwise the data controller would have no duty to choose a processor who provided any security guarantees simply because the data processor couldn't themselves identify data subjects. So if, for example, a data controller engaged in an archiving business to store its pseudonymized personal data, it wouldn't have any duty under the Act to ensure that the archiving business stored the material properly. And that would be a weird regulatory gap, because it would put pseudonymized data at obvious risk of harm, whether that be loss, destruction, damage, alteration, or anything else. So those are our submissions under the second topic. And I'll move on to the third and fourth topics, which are both significantly shorter. And our third topic is the SRB case, Single Resolution Board case at tab 17 of your authorities. And that's addressed in our supplementary skeleton at tab 15 of the core bundle. And at tab 17, you've got the Advocate General's opinion and the CJU's judgment. And you've actually also got at tab 16 the first instance judgment of the General Court, but not necessary to go to that because the CJU has adopted a different analysis. The significance of the Single Resolution Board judgment, we say, is that it's the only time, apart from this case, that either a domestic court or the CJU has specifically addressed the question of how a data controller's own duties to data subjects are affected by the fact that the data, if obtained by a third party, wouldn't allow data subjects to be identified. And the background is this. A failing Spanish bank had been placed under resolution by the Single Resolution Board so that it would avoid insolvency proceedings. And as part of that, the board had asked the auditor, Deloitte, to undertake a valuation to see if the bank's shareholders would have received better treatment if the bank had been subject to insolvency proceedings and whether they should get compensation as a result. And as part of that process, the board had invited shareholders to express an interest in being heard. And that process required shareholders to produce personal data to verify their identity and ownership of shares, and then they could submit comments. But the comments were then separated from their personal identifiers and provided to Deloitte in pseudonymized form. And each comment didn't have a name associated with it, it just has an alphanumeric code. And several shareholders complained on the basis that they said they hadn't expected their data to be transmitted to Deloitte. And they said it was a breach of their data protection rights because it was contrary to the board's privacy statement. So the allegation was that the Single Resolution Board had breached its duty to provide transparency information to data subjects about how their personal data was going to be used. That duty that had been breached was a duty that one sees in the relevant regulation was Regulation 2018-1725 concerning the processing of personal data by EU bodies, but the case has a direct read across to the directive and to the GDPR because the meaning of personal data is the same across all three pieces of legislation. One sees that made as a preliminary point at page 509. So that's paragraph 52. And the first issue was whether these pseudonymized comments that went to Deloitte were personal data at all. And the CJU agreed with the European Data Protection Supervisor that they were personal data because they expressed the data subject's views. That's paragraphs 57 to 60, page 510. The next question was whether they were personal data in the hands of Deloitte if Deloitte couldn't identify the individuals who'd made the comments but only had an alphanumeric code. And there, the court held that the comments didn't fall to be treated as personal data in the hands of Deloitte simply because the Single Resolution Board could identify the data subjects. In other words, exactly the same approach that I took you to earlier, that information can be the personal data in the hands of one party who's got the means of identifying data subjects, but not in the hands of another party who doesn't. One's got that point crisply made at paragraph 86, page 514.
Hold on.
But
Yes.
then,
Yes.
thank you. But then one gets to the critical issue, which is whether the transparency duty applied if the recipient only got information in a form which meant it wasn't personal data in their hands. And the reasoning on that point starts at page 516.
Can you just show us the transparency duty? Is that set
Yes,
out?
yes, of course, my lord. And it is page 482.
Thank you.
Is it paragraph 6 of the decision? Article 15.
Yes, I think my lord's probably found a much more convenient place of looking at
Within
it.
the judgment.
Yes,
Yeah.
yes.
Page 501.
Yes, it's page 501. Yeah.
Thank you.
It's worth saying that this, as my lord will know, I mean, this transparency duty is effectively materially identical to what's in Article 13 of the GDPR. One has a sort of
Yeah, this is
slightly less.
effectively just a transposition of the GDPR into the context
Yes.
of EU institutions.
And within the 1998 Act, the transparency duty is there, but in a sort of slightly less developed form, and it's the duty of fair processing, read with paragraph 2 of part 2 of the schedule,
It's
so pages 20 and 29.
the thicket, as it was once described.
Yes.
Right, thank you. Yes. So sorry, where are you taking us to?
Yes. So.
98.
My lord, yes, and I was going to take you to the sort of critical issue, which is whether the transparency duty applied
Yes.
if the recipient only got the information in a form which meant it wasn't their personal data for them. And that reasoning starts at page 516 and paragraph 98. And perhaps without trespassing too much on your time, it might be quickest if I just ask you to read paragraphs 98 to 116, and I'll then make my submissions on them.
Thank you. Yes.
So in my submission, one sees there 4 steps in the reasoning. First of all, the question of the perspective from which personal data falls to be assessed is context sensitive. That's paragraph 100. Secondly, in this context, the transparency duty applied at the time the data subject provided their personal data to the controller. Paragraph 103. Thirdly, fairness required that the data subject should know at the time they provided the personal data what was going to be done with it and what the consequences of providing the data would be. And therefore, the identifiable nature of the data subject had to be assessed at the time of the collection of the data. And that ultimate conclusion is paragraph 111. And fourthly, it followed that the single resolution board's argument that you have to put yourself in Deloitte's shoes would have the effect of shifting the timing of the Article 15 obligation to the point of disclosure, not the point when the data subject provides the information. And it would also disregard the purpose of the transparency obligation, which, as one sees, quoting the end of paragraph 114, is intrinsically linked to the relationship between the controller and the data subject. So in other words, not about the relationship between the data controller and the person who receives the data. And we say those strands of reasoning have real resonance here. First of all, and critically, the CJEU's reasoning makes clear that as a matter of principle, the data controller may still have substantive data protection duties linked to the fact that personal data may be obtained by a third party, even if the information would not be personal data for that third party. And that itself helps to explain why the FOIA cases, that is my next and last topic, are not the answer here. Secondly, the CJU's reasoning makes clear that the context and nature of the data protection duty in question matter when considering the perspective from which to view the meaning of personal data. And the important points here were that the Article 15 duty applied at the time the data was obtained from the data subject and arose out of the relationship between the data controller and data subject. And we say those points have real resonance here, and that's because DPP 7 is an anticipatory duty that applies from the time that the data controller first gets the data subject's personal data, albeit it applies throughout the time the data is held. And the purpose of the duty, obviously, is to protect the data subject. So in that sense, it is intrinsically linked to the relationship between data controller and data subject, just as here the Article 15 duty was said to be so linked. See the end of paragraph 114. Now, my learned friends say, well, this case is different because Article 15 is a one-off duty that only applies at the beginning of the relationship. You'd only need to tell people once what you're going to do with their data. and it's about transparency and telling the data subject something, which is different. But we say those are not material points of distinction. And if anything, the contextual reasons for DPP7 applying to everything that is personal data in the controller's hands, whatever its status in the hands of a third party who gets hold of it, are even stronger than they are with Article 15 here. And that's because the point of Article 15 is ultimately the protection of the data subject's privacy. And one might say, well, where's the harm to privacy if data is disclosed to a third party who can't identify the data subject? But by contrast, the focus of DPP7 is on security of personal data. And as I said earlier, there are many ways in which the security of personal data can be harmed by a third party, even if the third party can't identify the data subject. So we say contextually, DPP7 is actually an a fortiori case. If one looks at the approach in this case, Single Resolution Board, and applies it across. So we say, on that basis, it is strong supportive authority for the Information Commissioner's approach to the meaning of personal data. So that is that's what I want to say about that CJU case. And my fourth and last topic is to address the domestic authorities on FOIA and explain why, in my submission, they can't be read across. And this concerns the line of freedom of information authorities, starting with the Common Services Agency case at tab 5 of your authorities, which establishes that the disclosure of pseudonymized data under the Freedom of Information Act is not to be treated as the disclosure of personal data if it's simply vanilla data in the hands of the public once disclosed. The Upper Tribunal dealt with this line of authority in some detail, and it's set it out at paragraphs 76 to 81 of its judgment, starting at core bundle, page 62, and then set out its conclusions on the applicability of it, starting at paragraph 119 of the judgment on page 78. And what I'm going to do is to actually, if I may, is to pick up what's said by the Upper Tribunal under the heading the case law, which is page 78, before just taking you to the case law itself. Because we agree with much of what the Upper Tribunal concluded about this, paragraph 119 and following. First of all, it said case law isn't determinative, which is obviously what we say, that's paragraph 119 itself. And we also agree with the Upper Tribunal when it observed that none of these FOIA cases are concerned with DPP7 or with analogous provisions. And we also agree with it when it said all of them involve the controlled disclosure of a known data set to third parties. And in fact, we say those are indeed the critical points of distinction. What we disagree with is the Upper Tribunal's reasoning at paragraph 123, which sums up what it considered to be the read across from the FOIA cases. And specifically, we say that the mistake the Upper Tribunal made is encapsulated in the sentence starting on the fourth line. As the risk to be guarded against is the risk of data processing by third parties, the question of whether personal data is involved is to be judged from the perspective of the data that the third parties can access. And we say that is a non sequitur for all the reasons I've already given in my submissions. doesn't reflect the language of the DPA, doesn't acknowledge that processing of personal data can be carried out by anyone, whether or not they know the identity of the data subjects, and doesn't reflect the dangers that can arise when personal data is processed by a person who doesn't know their identity. But we also say that's not a conclusion that follows from the FOIA case law. And it's helpful just to look at a couple of the FOIA cases to understand the context for the approach they take and why that same approach doesn't apply when you're looking at DPP7. And the starting point for the domestic case law is the Common Services Agency case at tab 5 of the authorities. Lord Hope gave the leading speech. And although it's a little bit difficult to identify a ratio from the various speeches of their lordships, it is that speech, and it's agreed to be that speech that contains the ratio of the case. The case concerned a request under the Scottish Freedom of Information Act for the release of statistics about childhood leukemia. And the Common Services Agency refused to release them, relying on the exemption in the Freedom of Information Act for personal data, the release of which would breach data protection principles. And just to see what the exemption is, it's set out at paragraph 6 of the judgment, page 92. And the factual basis for the application of the exemption was said to be that because the numbers were so small and they were broken down in the way they were, individuals could be identified from them. The requester, the person who requested that information, Mr. Colley, complained to the Scottish Information Commission about the refusal to release data. And on page 94, one can see from paragraphs 10 and 11 in Lord Hope's judgment that the Scottish Information Commissioner agreed with the Common Services Agency that the statistics were personal data, the breach of which would breach the DPP, but then ordered the statistics to be released in an alternative form, a Barnardized form as it's known. So that's a form which would hide the precise figures but reveal a general pattern on the basis that that could be done without identifying individuals. And the Common Services Agency appealed against that order. And against that background, the argument is relevant, was all about whether the Barnardized statistics were personal data, and if so, whether their release in that Barnardized form would meet the data protection principles. Now, turning to the sort of meat of Lord Hope's reasoning, on page 97 at paragraph 22, Lord Hope makes the point that the duty in section 4 sub 4 of the 1998 Act is all-embracing, applies to all personal data, and that personal data can't be excluded from the meaning of the 1998 Act simply by editing it so that a third party who gets hold of it wouldn't be able to tell who the individuals within it were. And at paragraphs 23 to 27, he then applies that to the Barnardized data. And essentially, the reasoning here is that although the data will remain personal data in the hands of the controller, the Data Protection Act must allow for it to be released in a fully anonymized form so that it isn't personal data in the hands of the recipient. And if that can be done, it doesn't need to be subject to the rigour of the data protection principles. So in other words, if Barnardization has been effective, the Barnardised information can be released under freedom of information legislation as pure vanilla data without the data protection principles applying. Now,
Can I go back to 22, paragraph 22?
Yes.
It says in the middle of that, he, i.e. the data controller, I think, cannot exclude personal data from the duty to comply with the data protection principles simply by editing the data, so that if the edited parts were disclosed, the third party would not find it possible from that part alone without assistance to identify a living individual. So it's saying it doesn't matter if you keep it in that sort of form, it's still personal data to which the data protection principles apply.
yes, yes.
Why doesn't that apply in our case?
Well, I mean, that principle does apply in our
Yes.
case, absolutely does, my lord.
Yes. Thank you.
So, CSA, this Lord Hope's reasoning was applied by the High Court in the Department of Health case, which is the next one to take you to, which is tab 7, where Mr. Justice Cranston addressed the meaning of Lord Hope's reasoning. And this case was similarly about statistical medical data, in that case, late-term abortion statistics. And as one can see from page 172, paragraph 38, the Department of Health resisted disclosure under FOIA on the basis that the statistics constituted personal data within limb B of the definition in the Data Protection Act 1998, because patients could be identified from the statistics together with other information in the Department of Health's possession. And the question was whether the CSA case supported that approach. Now, turning to Mr. Justice Cranston's reasoning, he looked at the various different speeches in CSA. I've not done that because I don't consider it necessary to do so for the purposes of what I'm saying to your lordships. But he, in paragraph 45, we can see that he locates the ratio of the case in Lord Hope's speech. And paragraph 49, the solution to the meaning of Lord Hope's reasoning is one that he found to be in the order that Lord Hope proposed, which was remission to the Commissioner to decide whether or not the Barnardised data could be sufficiently anonymised for it not to be personal data. Paragraph 51, he explains that the only possible interpretation of that order is that although Lord Hope recognised that the agency itself held the information as to the identities of the children to whom it related, it didn't follow that the information sufficiently anonymised would still be personal data when publicly disclosed. So that's just interpolating. That's the interpretation of paragraphs 23 to 27 of Lord Hope's speech that I've just given your lordships, my lady. At 52, page 177, the judge explains that the CSA case is concerned with the implications of disclosure by the data controller and hence Lord Hope's order. So that's lines 3 and 4. Therefore, the concentration is upon what status the data has in the hands of the recipient rather than upon what its status is in the hands of the controller. One sees that as a thread running throughout paragraph 52. And then at paragraph 54, he addresses what are essentially the sort of policy reasons for that approach. And he says any other conclusion would be divorced from reality, because the Department of Health's interpretation, you have to look at, you have to treat this statistical information as personal data even when disclosed. means that any publication of this sort of data would amount to the processing of sensitive personal data, because information about health is a form of sensitive personal data, and that would make it, in essence, impossible to publish even innocuous statistical information of this type, because there wouldn't be a lawful basis for releasing sensitive personal data to the public. And he says that wouldn't be realistic, because it would mean, for instance, you couldn't publish information that 100,000 women had had an abortion in a particular year if you had access to information which meant you, original data controller, could identify each of them, even if the public could never identify them. So that's the Department of Health case, and there are 3 other Upper Tribunal authorities in this line of case law in the bundle, which you have at tab 6, APGA, tab 10, Miller, and tab 11, Spivak, but those don't, in our submission, say anything materially different, so you may be relieved here I don't need to take you to them. But my basic submission on this line of case law is the controlled release of personal data under FOIA is a completely different context from DPP7. There is no read across. And there are 4 related points to make about that. First of all, the FOIA cases make clear that context is all important. That's plain, we say, from paragraphs 26 to 27 of the CSA case, and it's plain too, and indeed expressly stated, at paragraph 52 of Mr. Justice Cranston's judgment in the Department of Health case. And the fact that the cases concern the implications of controlled disclosure by the data controller to the public is explicitly stated to be a critical part of the context. See what Mr. Justice Cranston says at paragraph 52 of the DOH case. Secondly, the FOIA cases are not about what might happen to personal data in the data controller's hands. They're only about what the public might do with sanitized information after it's been released. And that explains why the perspective from which the court needs to consider the data is its status in the hands of the public, not its status in the hands of the data controller. Thirdly, as Mr. Justice Cranston's judgment indicates at paragraph 54, which I've just taken you to, there are strong reasons of policy and common sense for reaching that conclusion in the FOIA context. As the judge points out, the consequences of any different interpretation under FOIA would have been very strange, because it would have prohibited the controlled disclosure of completely sanitized statistical medical information to the public, simply because the data controller held the key. And therefore, it would have prevented the release of harmless information in the context of a freedom of information regime, the very purpose of which is to allow the release of information where that can be done without harming the public interest. And the 4th point is an explanatory one concerning the interests at stake, which helps in my submission to explain why the context of FOIA and the context of DPP7 drive different conclusions. The only interest of the data subject that falls for consideration in the FOIA cases is their privacy, not the security of their personal data. And that's because in the FOIA cases, data security is simply not at issue. It's assumed that the data controller is holding the information from which the pseudonymized data has been derived securely. in compliance with their DPP7 duty. And if you're just looking at privacy alone, then the data subject's privacy is not affected if the only data released is vanilla data from which they can't be identified. And none of those points applies in the context of DPP7. You are dealing here with unauthorized or unlawful processing, not controlled disclosure. And that means one cannot be satisfied that the data subject's interests are unaffected simply because the third party doing the unlawful processing can't identify them. For example, as explained earlier in submissions, third party can alter or destroy the personal data. And the interests of the data subject at issue don't just concern their privacy, but all their other interests that might be affected if their data is not held securely. So we don't dispute any of the principles in the FOIA line of case law, but we do say that it clearly doesn't apply here. It can't be read across, as the Upper Tribunal did. And the final point to make on the application of these FOIA authorities is to address what's said in paragraphs 73 to 74 of my learned friend's skeleton at page 231 of the core bundle. Now, as we understand it, the point that they make there is to say, well, suppose you've got a data controller who holds a completely secure master copy of personal data, and all a third-party attacker gets is a separate copy of pseudonymized data from which data subjects can't be identified. That's the same in practice as the position in the Common Services Agency case and all those other FOIA cases. So why should the legal analysis be any different? That's what we understand that point to be. And there are two answers to that. First of all, it's using the presumed facts of a breach to define the nature of the duty, which is getting things the wrong way round. In other words, it's reasoning back from a narrow set of assumed facts. The fact that some data might be harmless if stolen because it's effectively pseudonymized and there's a master copy of it shouldn't lead to a reading of the duty which fails to protect personal data against harm by a third party simply because they can't identify the data subjects. Secondly, if all that an attacker can get is true vanilla data and they can't get a master copy of the personal data held on the data controller systems, the answer may sometimes be that the data controller has complied with DPP7, the data security duty. But that's not because the pseudonymized data isn't to be treated as personal data for the purposes of DPP7 and the reference to unauthorized and unlawful processing of personal data. It's because the controller may have taken appropriate technical and organizational measures, atoms, to protect it under DPP7 by A, pseudonymizing it, and B, ensuring that a secure master copy is held on its systems. In other words, we of course accept that in appropriate cases, the same conclusion that there's been no breach of DPP7 could potentially be reached. But it would be reached by an analytically sound path that requires one to look at the facts and consider whether on those particular facts appropriate technical and organizational measures, atoms, have been taken to protect personal data. And that's how one ought to analyse the question of compliance with DPP7, not through the binary question of whether data is personal data in the hands of an attacker. And that, we say, is completely appropriate because it allows for a much more fine-grained and fact-sensitive analysis, which doesn't depend upon a yes-no answer to whether information is personal data for the attacker. And indeed, one can imagine that there may be circumstances where even when a controller has a master copy and has pseudonymized data, so that all an attacker can get hold of is pseudonymized data, and the data controller still won't have lost anything, even then it will be a fact-sensitive issue as to whether DPP7 is being complied with. Just to think about this in a hospital context, one might have a hospital that had a whole load of data that it used on a day-to-day basis, where it just used numbers rather than patient names. An attacker might get in, perturb that data, change it, destroy it. It could, could be highly inconvenient and disruptive, even if the hospital still had a master copy. And in those circumstances, one might say, well, DPP7 has not been complied with. But as I say, it is the analysis of appropriate technical and organisational measures that ought to be doing the work here, not the approach taken by the Upper Tribunal and DSG. So, my lords, my lady, can I just check behind me to see whether I've covered everything that I should have covered?
No, thank you very much. Yes, Bhupen.
Your Lordships just allow me a moment to get my papers in the right order. My lords, my lady, as the court will have seen, the Upper Tribunal's decision in this case covered quite a wide field and a number of different issues and aspects. The Upper Tribunal addressed the issues under 5 headings. This appeal only relates to the first of those 5 headings, the first of the 5 issues that the Upper Tribunal addressed. And the appeal comes down to a narrow point of construction as to how DPP7 works in the context of the 1998 Act. And turning again to the grounds of appeal, which you have at page 13 in the core bundle, the ground of appeal is admirably succinct. The Upper Tribunal erred in law by holding that a data controller is not required to take appropriate technical and organisational measures against unauthorised or unlawful processing of data by a third party, where the data is personal data in the hands of the controller, but not in the hands of the third party. So essentially, the issue is, how should the court interpret the obligation of a data controller to take appropriate technical or organisational measures, or ATOMs as they're sometimes referred to for short, against unauthorized or unlawful processing of personal data, where data is personal data in the hands of a data controller, but wouldn't be personal data in the hands of a third party, to what extent is the data controller required to protect that data in respect of the third party? Now, so that the court can see where I'm going, I want to structure my submissions in the following way. I want to begin with some introductory remarks. Then I want to say something about two aspects of the Data Protection Act 1998. Firstly, the definition of personal data, and secondly, DPP7 itself and the related provisions that assist with its interpretation. In the light of that analysis, I can summarize what we say is the correct approach to the issue of construction. My remaining submissions are then by way of further support for that approach. So I want to look again at the relevant part of the Upper Tribunal's decision to explain how their analysis reflects what we say is the correct approach. I then want to look at some of the case law, in particular case law both in the UK and the EU, about the situation in which the same data is personal data in one party's hands, but not in another party's hands. Fourthly, I want to address the ICO's arguments in their main skeleton and as developed today. And finally, I want to deal with the SRB case on which both parties have submitted supplementary skeleton arguments. Now, we say, so I'm now on the introductory part of my submissions, we say that the Upper Tribunal's analysis of the construction issue was correct, in particular as set out in paragraphs 112 to 118 and 123 of their decision, which is the part of the decision that's attacked by the ICO. In relation to one part of that reasoning, I'll be inviting the court to read that in conjunction with what the Upper Tribunal said when refusing the application for permission to appeal. That part of the decision related to the first of DSG's, to the first of the 5 issues that the Upper Tribunal addressed. There's no challenge to the Upper Tribunal's reasoning in respect of any of the other issues that they addressed. So looking at what the Upper Tribunal said about that first issue, that's the subject of this appeal, put very briefly, we say that that part of the Upper Tribunal's analysis, firstly, properly reflects the language of DPP7. That is to say, we say it gives the language its natural meaning. If one reads the language with care and attention, and with reference to the fact that DPP7 contains, in substance, 2 different obligations, 2 different linguistic units. As to that, we agree with my friend that there are 2 separate linguistic units within DPP7 and that they need to be approached separately. We don't agree with the way that he's characterized those units. In particularly, we don't agree that the first one is in relation to deliberate acts and the second one is in relation to accidental acts. We say that either unit can cover both deliberate and accidental acts. I'll come to that in due course. So in relation to the language, we say that our approach gives the language of DPP7 its natural meaning. In relation to consequences, we say that our approach doesn't have the adverse consequences that are of concern to the ICO. The ICO's primary concern seems to be that there are certain sorts of harmful conduct that on our interpretation would fall outside the scope of DPP7. This is what we characterize in our skeleton argument as the ICO's argument from a regulatory lacuna. We don't accept that our construction gives rise to a regulatory lacuna. If anything, it is the construction that is adopted by the ICO itself, particularly in relation to the second limb of DPP7, the second obligation, that gives rise to the apparent lacuna. So we say, to the extent that there is a problem, it's a problem of the ICO's making, not a problem of our making. Further, we say that the Upper Tribunal's approach is supported by case law about how the definition of personal data works, and in particular, case law about the situation where data is personal data in the hands of one party, but not in the hands of another party. And we say that it's the ICO's construction that is a strained construction, and we say that there's no need to adopt that. Still in my introductory section, I wanted to say a little bit about the factual context. The court will now be familiar with this, so I can take this shortly. The data with which this appeal is concerned is data that was scraped by third-party attackers from DSG's point-of-sale terminals. It's summarised at paragraph 3 of our skeleton at page 209 of the core bundle. I don't need to ask the court to turn that up now. That data, the data from the point-of-sale terminals, is not the only data to which the ICO's monetary penalty notice related, i.e. it's not the only data in respect of which the ICO found that DSG was in breach of DPP7, but it is the data that was relevant to ground 1 of our appeal before the Upper Tribunal and to issue 1 in their decision. So the issue in relation to the data that was scraped from the point-of-sale terminals is whether DSG was responsible for a breach of DPP7 in failing to protect that data against third-party attack. If not, then any failing by DSG in relation to that data could not go to support the imposition of a monetary penalty notice by the ICO. Now, I've said that there was other data that was also affected by the attack, and that other data was also referred to by the ICO in the monetary penalty notice. But the monetary penalty notice paid particular emphasis to the data that had been scraped from the point-of-sale terminals, which was why, in turn, that data bulked large in the argument before the First-tier Tribunal and before the Upper Tribunal. Now, something that my friend has said about DPP7, and that is common ground, is that the duty under DPP7 is an anticipatory duty. It's a duty, putting it shortly, to protect data, to keep it safe. When one has a case like the present, where there is a successful cyber attack, which leads in turn to a monetary penalty notice, it's always tempting to look at the attack and say, well, it's the attack that constitutes the breach of DPP7. And that, I accept, is the wrong approach. The breach of DPP7 is the failure to adopt appropriate technical and organisational measures. The attack is simply, or maybe simply, an indication that measures have not been adopted. That said, the monetary penalty notice here and the way that the case has been argued before the First-tier Tribunal and the Upper Tribunal is very much that the failure of DPP7 consisted in a failure to adopt appropriate measures in relation to the data that was affected by the attack. So the ICO hasn't put its case on the basis that, well, you got lucky, that this data was the only data that was affected by the attack, because there's all sorts of other data that could have been affected that you were also failing to protect. So in that sense, the monetary penalty notice is very much tailored to the data affected by the attack. So that really goes to reinforce the point I've made, that the fact that the PAN data, the data scraped from the point of sale terminals, bulks large in the monetary penalty notice and in the subsequent argument, what that really indicates is that the alleged failure properly to protect that data bulked very large in the imposition of the monetary penalty notice. As it happens, because of the findings of the Upper Tribunal in relation to the other issues before it, issues 2 to 5, whatever the outcome of this appeal, firstly, this case will need to be remitted to the First-tier Tribunal, and secondly, the First-tier Tribunal will need to grapple with the question of whether the point of sale data would have been personal data in the hands of the attackers, because that issue is also relevant to matters arising from the other issues addressed by the Upper Tribunal that were not the subject of this appeal. But I don't need to trouble the court with those other issues. Now, to say a little more about the data from the point of sale terminals, the attackers scraped data from those terminals in respect of the vast majority of those cards. The only data that the attackers obtained was the 16-digit primary account number, or PAN for short, and the expiry date of the card, not the cardholder's name. And the reason that the success of the attack was so limited was that the vast majority of the cards were protected by the EMV system. So that data, PAN and expiry date, but not cardholder name, that is what our skeleton refers to for short as the EMV data, as did the Upper Tribunal. So in the context of this case, the relevant issue, tying it to the facts of the case, was whether DSG breached DPP7 by, put shortly, failing to protect the EMV data against third-party attackers. Now, before the First-tier Tribunal, both DSG and the ICO made extensive submissions as to whether the EMV data would be personal data in the hands of a third-party attacker. And that issue was approached under two headings. Firstly, whether the EMV data on its own and viewed in isolation without reference to any other data constituted personal data. That was what the tribunals referred to as a Lim 1 approach. And secondly, whether that data in the hands of the attackers would constitute personal data in their hands in conjunction with other data that would or might be available to them. For instance, other data that they might be able to obtain on the dark web. And that was referred to as the Lim 3 question. Before the First-tier Tribunal, both parties proceeded on the footing that one way or another, the first-tier tribunal would need to resolve the question of whether the EMV data was personal data in the hands of a third-party attacker in order to apply DPP7 to the facts of this case. Now, the first-tier tribunal took a different approach. They said that this question didn't need to be resolved. They said that that was because the EMV data, or some of it at any rate, was personal data in the hands of DSG itself. And the FTT said, the first-tier tribunal said, that that was all that mattered. And because of that, it didn't need to resolve the separate question of whether the EMV data was or would be personal data in the hands of a third-party attacker. In relation to issue 1, essentially what the Upper Tribunal said was that the first-tier tribunal took a wrong approach. The Upper Tribunal held that the resolution of that question, whether or not the EMV data would be personal data in the hands of a third-party attacker, that was something that needed to be resolved, said the Upper Tribunal, in order to apply DPP7. That was an issue that the Upper Tribunal itself didn't consider that it could properly resolve on the material before it, so it treated that as an issue to be resolved by the first-tier tribunal on remission. Now, effectively, for the purposes of this appeal, and this again is, I think, common ground between us, we're inviting the court to proceed on the basis of an assumption that the EMV data would not be personal data in the hands of a third-party attacker, because it's only if that assumption is correct that one can then say, well, the ICO is right, that that is a question that doesn't need to be resolved in order to decide on the scope of the DPP7 obligation. So that's what I wanted to say by way of introduction. I want to turn now to the key concepts and how they apply. And to some extent, I'm going back over ground that my friend has already taken you to. So I can take this rather more shortly because of the prior work that he's done. But can I begin with the definition of personal data in the Data Protection Act 1998? And you have that in the core bundle. If you turn to page 12, sorry, the authorities bundle. If you turn to page 12 in the authorities bundle, behind tab 2, you have the Data Protection Act. The scheme of the Act, the definitional scheme, is effectively this. Firstly, you have information, and information as a term is not defined. So the Act assumes that information is something that we can all recognize. Data is a subset of information, and data is information which has the characteristics set out under the definition of data. And I don't need to address you on those characteristics for the purposes of this appeal. Personal data, in turn, is then a subset of data which relate to a living individual who can be identified, A, from those data, or B, from those data, and other information which is in the possession of or is likely to come into the possession of the data controller. Now, that definition of personal data is often approached in two stages. Firstly, does the data relate to a living individual? Secondly, can the individual be identified? One sees that in the SRB case, which dealt sequentially with whether the comments that were provided, whether those related to the people providing the comments, and if so, whether those people were in a relevant sense identifiable. This case is only concerned with the identifiability questions, not with the relate to questions. And as my friend has shown you, there are two routes on the face of the statute whereby an individual can be identified, A, from the data, and B, from those data and other information which is in the possession of or is likely to come into possession of the data controller. Now, my friend also showed you recital 26 of the directive, which you find behind tab 1 at page 4 in the authorities bundle. And just to read the first couple of parts of that definition, whereas the principles of protection must apply to any information concerning an identified or identifiable person, whereas to determine whether a person is identifiable, account to be taken of all the means likely reasonably to be used either by the controller or by any other person to identify the said person. So what one sees there, which is not on the face of the definition in the Data Protection Act, but it's common ground between us that that definition needs to be read by reference to the directive, including the recital. What one sees there is a reference to identification by a third party. Now, it's for that reason that one sees in the First-tier Tribunal decision and the Upper Tribunal decision the use of this language about limb 1, limb 2 and limb 3. And it's helpful to say a little bit about that, simply because that assists in following the reasoning. So what they called limb 1 data was data that identifies a living individual directly without the need to look at any further data. And you may have seen in the Upper Tribunal decision that issue 4 involved consideration of whether the PANs were personal data in that limb 1 sense, whether standing alone they were personal data. The Upper Tribunal said they weren't. The ICO hasn't appealed against that, so that's common ground. Then what they called limb 2 data was data which identifies a living individual directly when combined with other information in the possession of, or likely reasonably to be in the possession of, the data controller. So in the context of this appeal, was there any other information in the hands of DSG such that the PANs were personal data in DSG's hands? And the answer is yes, and we accept that that is the case. Now, the First-tier Tribunal seems to have thought that that was the case because, or partly because, the PANs, or some of them, could have been combined with other data that was also accessed by the attackers in the data breach. Now, we do not accept that the PANs could be combined in that way by DSG, or indeed, for that matter, by the attackers, but we do accept that DSG held data in a separate database that would enable it to identify the individuals to whom the PANs related. So we accept on that basis that the PANs were personal data in our hands under limb 2, and we accepted that before the Upper Tribunal. And then limb 3 is the case where the additional information is, or is reasonably likely to be, in the possession of the third party. So in this case, the PANs would be limb 3 data if there was other information available to a third party attacker that would enable them to make the identification. Now, it follows from all of that that the very same information may be personal data in the hands of one party, but not in the hands of another party. And it's common ground between us that that can be the case. The issue between us is what's the significance of that? So if one takes the case of data that's been pseudonymized by the data controller, it was clear from the submissions for the commissioner that a particular concern for the commissioner is how DPP7 would apply in relation to pseudonymization. So it may be helpful to think rather crudely of pseudonymization as involving taking data and dividing it into two buckets in the hands of the data controller. Let's say in one bucket, you have a list of codes, each one representing an individual, together with information about the individuals. So let's say it's a simple alphabetical code where you say individual A has not been hospitalized in the past 12 months, individual B has been hospitalized twice in the past 12 months, etc. That's the first bucket. And then assume that in another bucket, you've got a key that identifies the individuals to whom the codes relate. So individual A is John Smith, individual B is Jane Brown, and so on. Is that first bucket, personal data, in the hands of the data controller? Answer yes, and that's because the data controller holds both buckets and can link the first bucket to the second bucket, which is where the key is that unscrambles the code. Is the first bucket personal data in the hands of a third party who doesn't have the key? The answer is it depends. It depends on whether there is other information reasonably available to the third party that tells them who these individuals are to which the codes relate. So in terms of a data controller who has pseudonymized data in that way, a particular concern of the Information Commissioner about DSG's approach is that it would encourage controllers to be unduly complacent and to think that all they needed to do was pseudonymize data and that that in itself would comply with DPP7. On our approach, the point I would want to emphasize is that in order to comply with DPP7, it would be very important for the controller to be able to show that the key was properly protected so that there was no risk of the key getting out and the key being accessed by a third-party attacker. And coming back to the facts of this particular case, it wasn't put, we accept, as I've said, that there was other information held by DSG that DSG could have combined with the PANs so as to identify the individuals. But that other information is not information that the ICO suggested that we had failed.
The duty is anticipatory.
It is.
So you have no idea who the prospective hacker is going to be. But your case is that the duty depends on the identity of the hacker and the information that might or might not be available to the individual hacker.
It doesn't depend on the identity of the hacker because one doesn't know what the identity of the hacker would be. It depends on the consequences of a hack. So what happens if this data gets out of our control and gets into the hands of a third party? Now, in the freedom of information case, you're looking at what happens if particular data leaves the data controller and is made public. So you're having to look at the whole spectrum of people who would have access to that data and saying, would any of them be able to make the identification?
So the duty under paragraph 7 depends on the consequences of the hack.
It does. It does. And that point is common ground between us, I would suggest. And it's common ground between us because of pretty much the final point that my friend made, my friend accepted that if data was protected in such a way that in the hands of a third party, it wouldn't be identifiable, then that is something that would be relevant to whether you'd met the standard of protection. Because the standard of protection, there's the separate paragraph that sets the standard of protection, and the standard of protection depends in part on the consequence if DPP7 is breached. So either way, the difference between us is perhaps narrower than might at first sight appear.
Sorry,
Because-
we're running over time, but
I'm
yes,
sorry,
go on,
yes.
no, go on, it's my fault for asking questions at an
because-
inappropriate time.
Whether we are right or the ICO is right, either way, the data controller has to concern themselves with what would be the consequence if this data got out of their control and got into the hands of a third party attacker. The ICO says that is relevant to the standard of protection that needs to be adopted. We say it's relevant at an anterior stage as to the scope of the sorts of thing against which the data controller has to guard.
So, yes, I mean, is your case simply stated that DPP7 doesn't apply if if the information? Well, forget it. I'm not going to ask that question now. It's past 1 o'clock. I'm not going to phrase it correctly. Okay,
I
stop
resist
now.
the temptation to answer the question
Yeah,
which
no,
I
don't,
thought my lord was
don't,
going to ask,
forget it.
and I shall
We'll stop.
I shall stop.
No, I think it's slow. So we'll stop now and start again at 2:05.
Thank you.
Thank you.
Court rise if able.